Good afternoon. My name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will listen to the particular article of Labor Standard Act, which is the Article 3, Standard Working Conditions. So, could you explain about this specific article, please?
Yeah, hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Thank you for asking. Today, I'd like to introduce the Article 3 of the Labor Standard. It's a standard of the working condition. The Labor Standard Act provides the working condition which are the minimum condition. So, if employer neglect to follow this requirement, then they'll be punished by criminal charge. So this we call it compulsory condition. The employer should follow. So even though there is a mutual agreement between employer and employee, and they decide to include the condition that is lower than the condition of the Labor Standard Act, then such a condition is null and void. So such an invalid condition will apply to the standard provided by this Labor Standard Act. So we call it the compulsory condition prevail the good faith principle. Of course, mutual agreement, if they have a better condition than the condition by the Labor Standard Act, then it's no problem. But the mutual condition is mutual agreement lower than the condition of the Labor Standard Act, then such a condition is invalid. That is what the Labor Standard Act explained by this article. So condition of the working condition according to the Article 3 of the Labor Standard Act.
Yeah, so according to your explanation, this Article 3 of Labor Standard Act is very strict, and if the employer do not meet the condition, and even between the employer and employee agree to certain condition, if it's lower than this standard, then it will be punished.
Yeah, that's right.
Is there a particular case that you wish to introduce?
Yes, there are some labor cases I represented previously. So one of those cases is one of the biggest the institute, language institute. So they had agreement with their workers, I mean English teachers. So they said we'll give like 1 million more. So please sign here. Will not be applicable to severance pay. So employer and workers, I mean English teachers, agreed on this mutual agreement. So they worked more than 1 year. Then when they resigned, they asked for severance pay. Then employer said, you agreed you will not receive severance pay, so we increased more salary instead of paying severance pay. So the English teachers said that is a violation of the Labor Standard Act. So good faith principle cannot violate labor law because the condition is lower than the condition of the Labor Standard Act. Like severance pay is mandatory money that the employee should pay, but if you maybe employer and employee agree to exclude this severance pay from their last salary, then that is violation. Yeah.
I see. So in this case that you explained that the employer wanted to save some money and not pay the severance pay, but at the end of the day, the employee requested the severance pay and they won the case. So it is very important for the employer to strictly follow and meet the Labor Standard Act Article 3.
Yeah, that's right. Yeah.
So, do you wish to add anything more about this?
Yeah, I think the standard prescribed by this Labor Standard Act provide the minimum condition. So even though employee and employee agreed on condition which is lower than the condition of Labor Standard Act, so such a condition this is invalid, then such invalid condition applied to the standard by the Labor Standard Act. So I think employee should remember the condition by this Labor Standard Act are minimum condition. So employer violate this condition, they will be punished by this this law. We call it criminal some violation if they do not follow this legal requirement.
So when did this Article 3 was finalized? And according to, in case of Korean Labor Standard Act, which international or law, foreign law, do we follow?
You mean
based on like a US or European or? So
okay, anybody who want to do their business in Korea must follow Labor Standard Act. Labor Standard Act is applicable inside of Korea, so it cannot be applicable in outside of Korea, because this is a mandatory rule that is applicable inside of Korea. So if employer is assigned to work in other country, they are applicable to their local labor law. So it doesn't matter what nationality they have, but as long as they work in Korea, Korean territory, they are applicable to this Labor Standard Act.
Yes, my question is, this Korean Labor Standard Act, which law, which international law, did we adopt before we stipulated this act? What, like European Labor Standard Act or US?
So this one actually, the constitution date, it was made like 1948 we introduced the Korean Constitution. So also our Korean Constitution was influenced by the Japanese Constitution. Also Japanese Constitution was influenced by some German Constitution that was established in 1919 Weimar Constitution. So those some constitution include a special right for workers, also some special the workers' right, like study right of labor. So our Labor Standard Act is originated from constitution. So in order to pursue their happiness, human dignity must be protected. How is it possible to keep their human dignity? So by this concept, working conditions should be determined by the subsidy law. That is guideline of the Article 32 of the Constitution. So in order to maintain or protect the human dignity, basic working conditions should be stipulated by some subsidiary act. That is a guideline from the Constitution. So this Labor Standard Act is originated from the guideline of the Constitution.
Yeah. I see. Thank you very much for your explanation.
Okay, thank you for watching. Bye bye.